Hey, Brian Parker here with another exciting video. I always say that, and you know what? Just spent an hour or so on this, and it is exciting. So let's take a look at today's video, which is, I'm going to put an interesting thumbnail, but this is a member from the state of Washington that fought back against Citibank. Before I get into that great story and show you all the documents and ways he beat Citibank, let me tell you this. With our Kill.ai, we have come up with a new turbocharge button. Let's call it that. It actually is called an enhanced button, but we call it a turbocharge button. And we're going to do like put a rocket on the button. So let me tell you what it is. So here is your basic inquiry if you go on Kill.ai. Let's just say you're not sure what you want, so you say this: Shazam, I received a collection letter for a debt I don't recognize. What should I do? If you click the enhance button, Shazam, see the orange button? Click that, and it populates into a much better analysis or a prompt, so you can get a much better response. Look at that. I received a collection letter from, then you put the debt collector name in. 4A, insert debt, debt they claim. Well, you can read. But what I'm trying to tell you is we've now got a new turbocharged enhance button. So we're making it even better for you. It isn't that we just have this AI approach to things that puts my brain and all 1,200 documents and ways of doing things into the website that you can easily access and create your own documents. Deep breath. We now have an enhance button that helps you populate or ask your question to get better responses. You do you, but this should help you just add, and this helps you add your law and facts and get the perfect product. Okay, moving on to the video. This is again about we're going to call it a gentleman named John, but it's a real member that faced a lawsuit from Citibank. So let's put that up there, Shazam. And that's your basic city. They're all the same, no matter what state you're in. I practice in a number of them. And let's just take a look at this. The defendant is believed to be a married individual and as such incurred the below, I'm not sure if any of that's true, but what a way to start a complaint. Defendant has been the obligor of a certain credit card account, and the defendant agreed by the use of the card, and there's reasons why they put that in there. You see my FCBA video. By the use of said credit card, nobody says anything specific because what's the rule? 9 out of 10, up to 9 out of 10 collection cases in the US just default or die to the detriment of the debtor. And interestingly, you're going to like what you hear today. If you don't show up to court, automatically defaulted. I don't need to preach that. That's a truth. That's my truth, but that is the truth. But watch what happens today in this video. So anyway, it's a basic complaint, and the client, the member, not my client, was going out of town, but as you know, with these things, you've got a certain amount of time you got to answer, and that's why you use Kill.ai to get that answer out, get a good answer out. So because he was blindsided by this lawsuit and he was traveling, he used, I'm going to tell you, he used SoloSuit. And here is SoloSuit's answer him. Shazam, that's the first page. And then let's put it next to each other. Who am I talking to? I'm talking to my editor, Cindy. Shazam, and that is a very basic answer. It saves you from a default, maybe, but do you see any leverage there? Is there anything where the Citibank's going, okay, we give in, can we pay you? No. But what John did when he got back to town, and by the way, looking at that SoloSuit, it's a bare bones answer. That's not a Brian Parker answer. There's no relevant affirmative defenses. It's just, what do they call it in the law business? Oh, boilerplate. That if you want to insult somebody about what they did and they may have spent the time on it, you just go, that's just boilerplate, meaning you can just throw anything against the wall and hope some of it sticks. That's what the SoloSuit, at least in front of me, is. There's no real discovery strategy when you're using SoloSuit that I know of, and it's zero counterclaims, just bare bones. So that's my opinion. So what to do? Well, when he got back to town, this is an advertisement, but he used, I'm reading what I wrote, he used the kill debt solution. But what he really did, and what I've been preaching to you all along, is create leverage. So that previous, let me put that up there again, that SoloSuit 2 pages, Shazam. I'm not changing my position on anything with that. There's no leverage. Now, what John did is he went on my site after he became a member, and he learned how to amend his answer. So that was kind of his plan all along. He just wanted a placeholder, a stopgap, but he wanted the real deal, and he came to kill debt, and he created a motion for an amended answer. So if you file, generally, let's point to Michigan, but they're all kind of the same, most states. If you file an answer and you're not happy with it, or something else came up, you've got a certain amount of time where you can go and amend the answer, and retroactively, meaning the new answer that you've amended jumps into the place of the old answer as though it never existed. So that's one way of doing it. If you miss, like in Michigan, it's 14 days, you can do it without asking for the court's permission, but he missed whatever Washington state rule was, so he had to file a motion to amend, and he filed it using killdebt.com's forms. You can find there's 1,100 forms there of all kinds, shapes, and crisis beta. Whatever it is you need is on there, and then go to kill.ai. It does all the work for you. You just put in the prompt, and again, we've got the new enhance, and boom. So that's what he did, and he set up a motion to amend, did his notice of hearing, and got a date to appear in front of the court and notice properly Citibank, who showed up, and no, Citibank ghosted him and the court. They did not show up. Now remember, what would happen, I want you to take a minute now, if you didn't show up for court? What do you think's gonna happen? That's what's gonna happen, right? You're gonna get defaulted. Citibank doesn't show up, and the court says, I'm not comfortable with that. I don't want to do anything without Citibank being here. In fact, let me put up his words, some of his words. The first paragraph, Shazam. John said, pursuant to our discussion on the forum, he had placed this interesting set of facts and the resolution on our community site on killdebt.com. I'm emailing you the documents in my Citibank case. I was served and then had to go out of town. I did not know if I was going to be back in time to timely file an answer, so I used SoloSuit. I did get back in time to file an amended answer and affirmative defenses. I did not file counterclaims with my answer. I was just not ready at that time. After I prepared and was ready to file the counterclaims, I had to file a motion for leave to amend and add the counterclaim. So remember, you have a statutory amount of time to amend your answer without asking for the court. And that's by way of what's called by way of right. You have a right to do that. But if you miss the time amount, then you ask for leave of court and ask permission. And by the way, amendments are freely given the earlier you ask for them. Because why wouldn't you give, it's not, as long as it's not prejudice and you have a good cause reason, courts won't turn you down. Most states are very liberal, and they embed it in their court rules, saying, I think in Michigan, it actually says amendments are freely given. I've seen amendments of a lawsuit right before a trial begins. That's very rare. You got to really convince the court. But if new evidence shows up, they'll let you do it. But the earlier you do it, the better. I also sent discovery this time. Citibank's initial response to my discovery was pretty vague and incomplete. They sent me a box full of statements and a copy of an unsigned credit card agreement. That's great stuff, because none of that is proof, right? But now you can say, look, this is what they did when I asked them, and they sent me unsigned stuff that wasn't the answer for what I asked. So at the hearing for my motion to amend This is the second paragraph. I'm just going to read it. I'm not going to put it up there. Citibank did not show up. I was there in person and ready to argue my case. Guess what the judge did? The judge was so taken aback that someone actually was defending these types of cases, she refused to rule unless Citibank was in attendance. Do you think that's going to happen if you don't show up? I pointed out that they were properly served with a notice on the motion. The cojones on this gentleman. I pointed out that they were properly served with the notice of the motion in the hearing. She did not want to hear it and said, no ruling unless Citibank is present. She moved the matter out 60 days. Can you imagine the court going, well, he didn't show up. I'm not going to default him. I'm just going to give him 60 days. I don't think this court has ever had anyone defend these types of cases. So it was clear she was not prepared. Nonetheless, shortly thereafter, I suggested to opposing counsel that a mutual walkaway would be in everyone's interest. That's very hard to do against a creditor. A few days later, they emailed me back and said they agreed they were going to walk away. Citibank required a separate settlement agreement. Okay. And we went back and forth on some of the language. Good for him. And we got that nailed down, and opposing counsel prepared the joint dismissal with prejudice. You want everything with prejudice. So some of the things John did was use our discovery toolkit, and he hit him with pointed interrogatories about securitization. They sent a box of billing statements and an unsigned credit card statement. In fact, let's put this up there. Shazam, what John said, for every securitization question, Citi wrote, it's the original and current creditor. To John said, translation, we don't want to talk about the trust that actually owns the receivables. So let's talk about the turning point. Shazam. At the motion hearing, Citi's counsel never showed. The judge was stunned that a consumer fought back. So I want you to remember about that. If you can stun someone, they're probably impressed with you and they're going to listen to you. So while he or she did not rule that day, Citibank can read the writing on the wall. A, they didn't show. B, they were quick to mutually discover a reason to settle this. And this is what happens with a well-prepared pro se defendant, like you and me. So that is you. So John used that window to propose the mutual walkaway. No money didn't come out of his pocket. Case was dismissed with prejudice. Citibank folded. So Shazam, lessons and takeaways. It's all about leverage, right? If you saw that you saw the SoloSuit answer. If John had done nothing but put that in, he's probably facing a summary disposition motion to have to pay everything. But he turned it around by joining Kill Debt and joining you as a member, and he turned his new answer, an activity in his motion to amend, into leverage. Leverage wins. A placeholder answer keeps you alive. That's what he did with SoloSuit. An amended answer wins the war. Affirmative defenses frame discovery. He made sure he made an issue of his affirmative defenses, which attorneys, treat as throwaway. They want to answer the lawsuit, they don't get defaulted, then they do a bunch of affirmative defenses. Well, the truth and the fact is, affirmative defenses are a form of pleading, the same as an answer is. They're just as important, and you can frame how you win. When you file affirmative defenses against someone, they look. If it's boilerplate, you're going to lose them. Trust me, your eyes blur over. But if you're like a Parker convert, you specifically write down, this is securitized, another creditor owns it. Here's a counter affidavit, exhibit 1. Here's where you screwed up. People take notice, and like this case, they settle. So counterclaims also are part of your leverage. When you go, as I was showing you in the last video, when you go into killdebt.ai, it automatically kicks out the counterclaim. It wants you to use that counterclaim, and I explained in that last video the best way to do that. And persistence pays, right? Judges respond when you show up prepared, even if opposing counsel doesn't show. Judges have to give us a fair shake, but John held his ground when he didn't get that fair shake, and he held his breath. Citibank wanted nothing to do with John's work on this, which is really killdebt.com. John did it all. He had a tool. That's what killdebt.com and killdebt.ai, especially killdebt.ai, fantastic tool, and speeds your response time so quickly. And now we've got that enhance button. I wanted to call it the easy button, but I think that was taken. So we've called it the turbocharge enhance button. Go check it out. So if you're ready to turn these lawsuits into dismissals, go to killdebt.com. With this video, I'm going to attach Shazam, the motion to amend that John wrote against Citibank, the amended answer he wrote against Citibank, a motion to amend against JP Morgan that I wrote 2 hours ago. You can have that. It's just in a separate case of one I'm actually litigating. As I'm writing, I'm like, oh, I'll just throw this in. So you get that, even though it's against JP Morgan. Remember, when I have a creditor video, you can use it against any creditor. So a Citibank philosophy and methodology, or how I use it, can be used against American Express. Just change the words and the facts. Or you can use it against Bank of America, because it's all the same, if you will, part and parcel of securitization. There's no contract. You don't own the debt. You own an account, etc., etc. A motion to amend, as I said, will be included, 2 of them. Discovery requests against Citibank that John wrote. They're John's, using our format. The dismissal motion that ended the case for $0 owed. I feel excited about that. My show notes, that's a lot of notes. So, hey, I'm Brian Parker. Somebody told me I don't say this enough. Like, love, and subscribe. Go check out the new enhance button and sign up. It's under $150. You get, oh, I got to tell you something. You get the Kill.ai with the enhance button, does everything for you. Killdebt.com, 1,100 documents, all my instructional videos. Did I mention the enhance button? But coming soon, based upon a member's request. There's no single issues here that I ignore if I can, just because only one person asked for it. There are a couple of people that asked this. You ready? I'm going to give you an entire nationwide federal and state database of FDCPA cases. I'm going to put it on killdebt.com, and I'm not going to charge you more. I'm just going to include it as the value. I'm working on it. I got 2 other jobs, so give me time, but that's coming up. But today, you learned about how a member, John, spanked Citibank. I'm thinking in my head what the thumbnail is going to be to get people to watch. But great job. I hope you follow John's method as he followed us. We're there for you. Killdebt.com. Thank you.